Ladies and gentlemen, good afternoon. My name is Jeff Isaacs. I'm the head of commodities here at Hill Dickinson. I'm moderating this webinar this afternoon along with my partner Fred Kneinenberg. Good afternoon to you. We have a number of people attending from Argentina and Brazil, so good morning to you. And we have a Singapore audience as well, so good evening to you. Welcome to the Hill Dickinson Commodities Team webinar on force majeure and frustration in sale and purchase contracts and carriage contracts in the agri-commodities sphere. It's a bit ironic that we're putting on a whole webinar about force majeure in English law when an English lawyer can't actually tell you what force majeure is. Unlike the equivalent vis major in civil law systems in Europe and elsewhere, force majeure is not a term of art in English law. It's a bit like describing an elephant to somebody. You know it when you see it, but you can't describe it or define it. So there's no definition as such of force majeure under English law. Instead, we have there's been a whole series of legal cases telling us what is and what isn't force majeure. So, for example, we know from these cases that the term force majeure does include war, strikes, embargoes, the refusal of a license, abnormal storms, flooding, transport, breakdown of machinery. But we know it does not, for example, believe it or not, include football matches or funerals. So the English courts, ever helpful, have told us that football matches and funerals do not amount to force majeure, but they won't tell us exactly what force majeure means. But despite all that, we've put together this webinar to explore this concept of force majeure that English law struggles with a bit. 4 of our commodities teams are speaking today: Fred Kneinenberg, Darren Wall, John McNeely, and myself. We are going to kick off, if I can get my slide working. Yeah, we're going to kick off with some general principles on force majeure. What is it? How does it affect the performance of contracts? How does it protect the parties to a contract if they're unable to perform? And then we're going to go a little bit deeper and look in more detail at how to make sure your contracts properly provide for potential force majeure situations and how to make those force majeure provisions work properly for you. And after that, we're going to get even more specific, and we're going to look at 3 examples of force majeure in practice. We're going to look first at Argentine load port strikes and how force majeure applies in those situations. And then we're going to look at weather and the effects of weather on the performance of contracts. And then we're going to look at import bans, where the goods cannot be imported into the intended country of destination. And then finally, if we've got time, we're going to set out some what we hope will be useful tips on how to ensure that you make the contractual force majeure provisions work properly for you. And if we run out of time, we'll circulate those hot tips in writing to the delegates later in the week. Before we start, can I just set out some house rules for the webinar? Can you please put your microphones on mute, and if you have the ability to take yourself off mute, please resist the temptation to do that. We can't have over 300 people all talking at once. Secondly, we encourage you to ask questions. That's what webinars are all about. So please, can you make sure that you submit your questions in writing using the chat function on your screen? If you just click on that little speech bubble at the top of your screen to the left of the hand, that will open up the chat function, and you can leave your question there in writing. We can't guarantee that we'll cover all the questions that are submitted, but we'll do our best. In the event we run out of time, we will prepare a question and answer sheet recording our answers to all the questions that have been raised during the webinar, and we'll circulate those to the delegates later in the week. Can you please also turn off your cameras? That will help us with the bandwidth and also stop the whole system from overloading and crashing. And finally, the whole webinar is being recorded. So no jokes, please, about Boris Johnson or Brexit, because they will be recorded for posterity. Everybody will receive a copy of the recording and of the presentation slides and of the question and answer sheet that I mentioned a minute ago over the course of the next few days. So I'm going to hand over now to John McNeely, who's going to start us off with some general principles on force majeure. So John, over to you.
Hello, everyone. Thank you, Jeff. So as Jeff alluded to, I'll first take you through some general principles of force majeure. I'll try to move through this relatively briskly so that we can get onto the case studies, which will apply the principles I describe, and I expect will be of greater interest and help. So as Jeff said, force majeure is a civil law concept designed to excuse one or all of the parties to a contract from liabilities and or obligations under the contract. It arises where there's been an occurrence of extraordinary events, specified events, or events beyond the party's control. Under English law, however, unlike under civil law systems, force majeure is not a freestanding legal concept which exists outside the terms of the contract. So it needs to be specified in the contract. Force majeure will not be implied into contracts under English law, so it can't be relied on where there is no express force majeure provision included in the contract. In order for the force majeure effects to operate, it's necessary to fulfill certain conditions. These are commonly referred to as the three tests, and they're listed there on your slides at 1 to 3. Firstly, externality. The circumstances that lead to non-performance must have been beyond the control of the parties. Secondly, unpredictability. The party looking to rely on force majeure must not be able to anticipate the occurrence of the event. If an event is foreseeable, a party must be prepared for it. 3, irresistibility. That is, it must not be possible to avoid the consequences of the alleged force majeure event. Now, contracting parties often modify the application of force majeure by imposing additional requirements. Contracts can require that a party must give notice before invoking force majeure. This is intended to give the other party the chance to firstly reserve its rights, secondly try to mitigate or reduce the probable losses, and thirdly investigate the alleged force majeure circumstances. Now, the burden lies on the party seeking to invoke a force majeure clause to bring itself within the ambit of that clause. No party will have a right to rely on force majeure to excuse its performance of any contractual obligation unless 3 things happen. These are set out at A to C of this slide. So taking A, there must be a clause in the contract that clearly covers the situation that has in fact occurred, or there must be wording that excuses performance where any other unspecified events outside that party's control occur. B, there must be a causative link between the events that have occurred and the party's inability to perform its obligations. Now, regarding B, some clauses require that force majeure events must have prevented a party from performing its obligations. Others state that it is enough for the events to hinder performance for a party to be excused. Often it's difficult to prove that a particular event has prevented a party from performing because it may be able to perform by means other than those intended at the time of contracting. C, the procedure specified in the force majeure clause must be followed. Where both points A and B are satisfied, a party will then need to ensure that it complies with the procedural requirements of the clause regarding, for example, giving notice of the force majeure event to contractual counterparties. If all requirements A to C are satisfied, then the party claiming force majeure is entitled only to do what the clause permits. Often clauses permit suspension of obligations for a period of time, but they differ about if and when a party is entitled to cancel the contract or whether they must perform once the force majeure ceases. And finally, it's important to bear in mind that force majeure clauses are drafted in a variety of ways, and the exact wording of the particular clause in your contract is key. So you must review that carefully. Now I can see that Fred, one of the co-moderators, has put up his virtual hand, so I'll let him step in at this point. Fred?
Hi, I've got a couple of questions. The first is that bullet point A, step 1 involves bringing the situation within the clause. But what if the wording is ambiguous?
Yeah, of course. So it's easier said than done being clear sometimes about whether the force majeure, the particular events prescribed in the force majeure have taken place. Where there is ambiguity, that will have to be resolved against the party seeking to rely on the clause, and also against the party who's drafted it. So if one party in particular prepared the clause in question, this general principle of English law, it will be construed against them.
Okay, and the other point that was mentioned was unforeseeability in relation to the event of force majeure that is cited by the party relying on it. But is it always the case that any category of FM in such a clause has to be unforeseeable, do you think?
So not necessarily, in that we often come across hybrid clauses where it might be a force majeure clause in name, but it may be better to take it as a sort of exception clause, in the sense that if an event that arises that's specified under this force majeure clause, if it on its wording the event it falls within that, the fact that it was not unpredictable at the time the contract was made won't prevent a party from relying on it, and the clause has to be essentially interpreted on its straightforward reading. And I think this is something we'll keep coming back to in the course of this. It stands to the specific wording of the clause in question.
And of course, there's the classic maritime case in the Court of Appeal of a couple of years ago, the Dickinson case, and that actually involved what we would call a hybrid clause, which contains FM elements, but also exceptions, which meant that the court had to go through quite a knotty exercise of untangling the different elements to find out what exactly the principles were that governed the clause and how they were to be applied in practice. So usually you'll see a hybrid clause rather than a pure FM clause or a pure exceptions clause. And there are distinctions between the two.
Yeah, thank you, Fred. I think, Jeff, have you got your virtual hand up now?
Yeah, John, if I may just ask you a quick question. I said in the introduction that there's no definition of force majeure under English law as such. And you invariably get force majeure clauses that list a number of specific events and then include some sort of sweep up clause or some sort of sweep up wording at the end. If you look, for example, at the GAFTA and phosphor prohibition clauses or FM clauses, they list the events and then say any other event comprehended in the term force majeure. Given that English law won't actually tell you what force majeure is, and if you have a potential event which isn't listed but has a sort of flavour of force majeure to it, how do you know whether it's covered by the clause? How do you know whether it comes within that sweep up wording?
Sure. Well, as I said, every force majeure clause has to be interpreted on its particular wording. So I think it's going to depend on the full context of that and the contract. There is case law commentary, although there is not, as you say, a specific definition of the term for force majeure. There are precedents on what does fall within it, and as you alluded to, that it doesn't cover football matches, funerals, bad weather, and I think that's something that we'll come to later. So it's going to be, and I think something again we'll keep coming back to, it's going to be very fact specific, the actual circumstances of the event and the wording of the clause as to whether it can be captured by that term force majeure.
So it's sort of fact specific and word specific. So you have to look at the whole contract and the wording of the force majeure clause itself.
Yes, I'd say so.
And I guess we get into difficult situations where you have a contract that simply says force majeure clause that simply says refers to performance being prevented by any event of force majeure, and then you have no wording to fall back on. Then I suppose you have to trawl through the cases to see whether your event has been decided to be force majeure or not. Assuming, of course, it's not a funeral, in which case we already know the answer.
Yes, yeah, I think that's right. Sorry, Darren, did you want to say something at this point?
Yeah, just jumping in very quickly. I mean, the closest we've ever got to a definition of force majeure is in the Critti Rex, and it's not an authoritative definition by any stretch of the imagination, but there is sort of wording within that judgment that suggests force majeure itself can simply be defined as an unpredictable event that's beyond the control of both parties that's occurred after the contract has come into being. I believe in the Critti Rex that was a charter party itself. So if you do have just that one line wording, any case of force majeure, that's the closest you're going to get, but it's not going to be ideal by any stretch of the imagination.
Yes, and I think that comes back to those three ingredients on this slide here that we've just been through. Yeah. Okay, great. I'll move on now then to just general comments on force majeure in contracts. So when considering whether there has been force majeure, there'll be a series of questions that need to be answered. Firstly, are the parties entitled to refuse to perform a contractual obligation by reason of force majeure or frustration? If there is no express force majeure clause, it will be necessary to rely or to try to rely on the doctrine of frustration, which can be more challenging. As to the second bullet point on this slide, if there is a force majeure clause, does the event in question fit within the specific parameters? This is key, and I think something that we've already gone into in a bit of detail. Thirdly, are there any notice requirements? If you're claiming force majeure, you should ensure that you meet these requirements. You should also ensure when contracting that you'll be able to satisfy such notice requirements. For instance, the force majeure clause may require an initial written notice of force majeure within a certain number of days, followed by service of a certificate from the local Chamber of Commerce within a further certain number of days. Can you obtain such a certificate within the time specified in order to satisfy that requirement? That's a problem we've seen before. Turning to frustration, this principle will coexist alongside a contract's express force majeure clause. It will therefore remain potentially applicable where the FM clause is not comprehensive and the parties have not excluded it. If the contract provides for the relevant event, for instance, under a force majeure clause, that will suggest that it does not give rise to frustration. That's because it suggests that the consequences of the event should be determined by applying the contractual provisions rather than by applying the general law. This isn't, however, conclusive. For instance, frustration may still apply where the degree of delay or disruption which has occurred is greater than that which the contract anticipates. And there are two key criteria for frustration on this penultimate bullet point on this slide. Firstly, the event must be external to the parties. Party can't rely on frustration if the event that prevents performance was brought about by it itself. Secondly, the event must make performance either impossible or radically different to that which the parties originally bargained for. Frustration can also be prospective in effect. That is, it can operate where it's clear that looking forward, the consequence of the event that has occurred means that the performance of the contract will either be impossible or radically different. As to the consequences of frustration, it operates automatically by force of law to bring the contract to an end without either party being liable for that. It does not need to be provided for by the contract to have effect, and it's a right that a party, and it's also not a right that a party must choose whether or not to exercise, so it doesn't require notice. By contrast, normally contractual force majeure provisions are suspensory initially. They don't lead to immediate termination of the contract, and they must be triggered by notice by a party. That is usually, but not always, the case. Finally, the second slide on general comments. As a general point, it's important to try and stay back to back as far as possible when you're contracting. For instance, where the FOB buyer will want to ensure that in those same circumstances, time ceased to count under its charter party. Now, this might be more ambitious than realistic, but as a general principle, it's worth bearing in mind. The same is true for a SIF seller, of course, as well. Now, similarly, a party in the middle of a chain of sale contracts will want to stay back to back. This is important in relation to the triggers for the force majeure event, but also for the consequences that are specified by the relevant clause. Now, as to the triggers for force majeure, if force majeure is declared under your contract up the chain, you want to be able to do the same down the chain. Similarly, as to the consequences, if your counterparty up the chain can terminate, if the force majeure event continues for 30 days, you will not want to only be able to terminate your contract down the chain if the event continues for 60 days. Now, taking the example of a party buying under a FOB sale contract and selling under a SIF sale contract, that party will want to avoid finding themselves in a position in which the seller under the FOB contract can be excused for non-performance under that contract, but as SIF seller, you can't do the same. In those circumstances, the party in the middle of the chain could find that they're in breach of their obligations as SIF seller, but have no right of recourse as FOB buyer. And finally, in this regard, just beware in particular of general terms and conditions when seeking to contract back-to-back. In this regard, it's easy to overlook particularities of those terms when contracting. And Jeff, I turn to you.
Yeah, John, just a quick question on which force majeure provisions apply in any particular situation. You're likely to have multiple possible sources of force majeure provisions. You can, so for example, you've got the contract itself, which the parties negotiate. Then you've got the standard form contract that they may have incorporated into their contract, you know, the GAFTA 38 in Argentina or FOSFA 53, or in sugar, you know, the Refined Sugar Association rules or the New York number 11 rules. Even perhaps a charter party may be incorporated. All these will contain force majeure provisions. Some might conflict with others. How do you deal with that? How do you work out which force majeure provisions actually apply when you've got different sources all bringing the force majeure provisions into your contract?
Sure. So that is, as you say, of course, pretty common, this kind of hodgepodge of clauses and trying to work out how they fit together. But that's what you have to do. It'll be assumed that the parties intended for these clauses to work together, even if they didn't necessarily in reality give that a great deal of consideration. But it will be assumed that they're intended to work together. So in the first instance, you'd be looking to interpret them as if they do. If that's not possible, and there's an unresolvable conflict between these clauses, then the terms of the documents that the parties agreed will prevail. So there may be an express provision for that in the contract saying that the main terms will supersede the terms of, say, the phosphor contract incorporated in the event of a conflict. And indeed, that will normally be the case, that it would be the typed clauses in the fixture note for the sale confirmation or the recap for the charter that will prevail. That analysis can, of course, get particularly tricky where multiple forms are incorporated, and that would require a close analysis to work out how they fit together, which ones prevail potentially, and the answer might not be an easy one to reach, I think.
Okay, thank you.
Fred?
Hi, it's just more of a statement than a question, but essentially it is this, that charter parties and sale contracts are very rarely back to back because they're different types of contract. One is a freight contract, the other is a contract for the sale of goods. So, for instance, you'll never see the GAFTA prevention of shipment clause in a charter party. And in fact, you're dealing with different types of counterparty as well. So ship owners will be using standard charter party forms which contain entirely different FM provisions and exceptions clauses to those that you'll see in a GAFTA contract or a phosphor contract. And really the theme of this talk is the party that's in the eye of the storm when there is an FM clause, which is, as you've said, the FOB buyer and the SIF seller who's chartered the vessel and will be in different positions potentially under the various contracts. So he may have bought on GAFTA 38 and sold on GAFTA 40. One's a FOB contract, one's a SIF contract. Both of those will have the prevention of shipment clause. but he may have chartered in on non-grain terms, for instance, where the FM clause is much smaller and narrower than its GAFTA equivalent, and will give rise to a different scenario for that CIF seller as charterer. So that party is really the one in the eye of the storm and faces the trickiest problem in terms of extricating itself from the situation. And that's really going to be the theme, I think, of the next case study.
Yep, I think that's right. So on that basis, I guess a good time to hand over to Darren, who's dealing with the first case study. Darren.
Yeah, thanks, John. So the first case study we've come up with today is focusing really on strikes. And when we were thinking about it, we plumped for the Argentinian strikes that took place last year. Not to say that this is the only place where strikes commonly happen. Of course, it's not unknown or unusual. Equally, Brazil, a popular place for strike action, as well as some ports across Europe. But what was different last year in the sort of the latter part of 2020 was the fact that the strike itself didn't last for the usual 24 hours or several days that we're all used to. There were a series of strikes that took place amid ongoing battles between the governments, the terminal operators, and employers of workers and their unions. The point there being, in October, I think there was a strike that lasted less than a day. And then we fast forward to December and there was a 20-day strike. So there were a series of these strikes happening, backed up at the time with strike notices being issued by GAFTA. And we were the recipients of some of those notices. And themselves, they were based upon letters issued by the Chamber of Argentine Cereal Exporters relating to action by a range of different unions, which included stevedores, pilots, and tug workers. Now, the issue that we had here was that the effect of the strikes itself was not to shut down operations completely. Throughout the entire period, certain terminals seemed to be able to reach agreements with the unions in question, which then permitted cargo operations to resume. Now, if we look briefly, if I go on to the next slide, I've put up there the GAFTA Prevention of Shipment clause, just as a flavour of the question, does a strike actually apply to the contract in question? And if we look at this particular clause, we can see straight away, paragraph E in the definition of event of force majeure, strike actually applies. But that's not enough. If we go back to what John was saying earlier about the causal connection, we can see it in the second paragraph. There is this requirement that performance is prevented by the event of force majeure. So what we're looking for here, which is key, I believe, is the causal connection. So we have the strike, we're in that realms, we're in that ballpark, but does it actually apply to the contract in question? You know, you can never really give a straight answer to this, yes or no, because the next stage of showing that the performance has been prevented from the seller's side tends to be very fact sensitive. There is the notice requirement as well, and under the GAFTA Prevention of Shipments, you've got the 7 days before issuing that you have to issue the notice, or if your delivery period is some way off, there is the 21 days prior to the beginning of that delivery period where you can have the ability to issue the notice. But as soon as you issue that notice, you know, you can expect to be pressed from your counterparty for the proof, the causation requirements. And in certain circumstances, such as this, where we saw certain terminals operating, that was not always clear cut as an answer. Fred, have you got a comment to make there? Because your hand is up, but I'm not sure you took that down when you asked the last question.
It was an event of force majeure, Darren. It was accidental.
Oh, okay, got you. So what we can see looking at the GAFTA Prevention of Shipment clause as well, to put this into context, is that we have the strike, we have that causation requirement we've covered, and we've got the notice requirement there as well. Moving forward, it's not an automatic cancellation, and one of the things we would always caution is never rush and claim force majeure in a notice and then say that the contract is hereby cancelled or terminated, because that's not what this clause provides for. It provides for, rushed ahead, it provides for a suspension of 21 days. So the event of force majeure continues for 21 consecutive days. And where we were in Argentina towards the end of last year, you had a series of strikes. So the first one lasted less than 24 hours. There was another strike that took place, and that would be classed as a separate event. So you have to have 21 consecutive continuous days of strike action after the end of that period of delivery before you then have the option to cancel. And if you don't exercise that option to cancel, what happens with this particular clause, you then get an additional 14 days. And at that point, the contract is automatically cancelled. So that's almost a flavour of frustration, if you will. So a seller that's tendered notice could well sort of cancel after that 21-day period has elapsed. But if he chooses not to, then there's that additional 14-day period. So moving forward, and keeping with the strikes, if we compare the actual GAFTA clause that I just put up on the screen, Jeff, you've got a question, I believe.
Yeah, sorry, Darren. Just referring back to your first slide, just a couple of points really. The first is this. Perhaps it's less of a question, more of a statement. But the standard clauses talk about performance being prevented by an event. They don't really go into the possibility of knock-on consequences of an event. So in particularly in a strike, you may have a strike that lasts only 2 days, but the consequences of that strike may be that the port becomes, or the terminal becomes, congested, and there's delay in the seller being able to get the goods on board. So it could be argued that the seller is prevented from performing by congestion, not by the strike. So to what extent can you rely on the consequences of the force majeure event to bring yourself within the clause?
Good question. This is when we come back to this whole fact-sensitive sort of diagram, I suppose, because you always have to look at where you are in terms of your performance obligations at the time the strike occurs. What I would say is, as long as you've tendered that notice to your counterparty, and as long as you have evidence, some evidence behind you to back up the fact that this is going to delay beyond the delivery period, then you're fine. But again, it all depends upon the terms of the contract itself, because you've got under the GAFTA contracts, typically under the FOB terms, for instance, as long as the buyer has presented their vessel, then the seller can actually load those goods at any time after the end of the delivery period. So it's not as if there's this automatic cutoff point. But in terms of reliance on the clause, as long as that seller can show the prevention aspect by virtue of evidence, whether that is an official Chamber of Commerce force majeure notice or even local press cuttings, information from agents, then a seller would be protected.
Okay, that's comprehensive reply. Thank you. Just one more point here. We've already seen that some force majeure clauses require the party relying on force majeure to provide evidence in support of the force majeure claim. Some of them are very specific, specifying exactly what needs to be provided with the notice. Some of them are super specific and say you must provide a certificate from this particular Chamber of Commerce specifying these particular events. You are very much in the hands of the particular body that's supposed to be issuing that certificate as to whether you get it or not. And in my experience, I come across situations where a Chamber of Commerce, for example, faced with a force majeure event, will refuse to issue any certification until the event is over. And of course, that may be too late in terms of getting the event in under your force majeure provisions. So what's the position there with a party who's obliged to provide evidence but actually can't get hold of it because the source of it won't provide it?
This is the classic reservation of all rights, I believe. You're right. at the end of the day, if the official notice that you are required by the contract can't be obtained at that time, then the fallback position would be to obtain as much evidence as you possibly can. And in this case, for instance, if the local Chamber of Commerce is refusing to until the end of the event, that must be in writing somewhere. And if there is that committed in writing, that should be sufficient to attach to a notice with a paragraph at the end saying further evidence will be provided in due course when available.
Yes, you'll then have some smart aleck lawyer acting for the recipient of that notice to say, well, that's all very well, it's all very interesting, but you haven't actually complied with the letter of the clause, so you can't rely on force majeure. I suppose then it all comes down to a question of interpreting the clause in question and working out whether the requirement to provide the evidence with the notice is a condition of the whole force majeure scheme.
I think a similar smart aleck lawyer might respond to that to say that that notice is to be provided at the earliest point at which it's available. It would be quite unusual to actually have that demand for the notice from the Chamber of Commerce at the very beginning as a prerequisite. You could almost always read into the language the fact that that evidence could follow later.
Okay, thank you.
Fred, I think, have you got a comment?
Just a brief one. The only gloss I would place on this particular point is I suspect this problem of obtaining specified documents is precisely why, e.g. the GAFTA Prevention of Shipment clause doesn't specify what must be provided, but just says evidence shall be provided. So it's generic rather than specific because of this issue of actually procuring the particular documents and giving lawyers like us work trying to get around the clause because of this over concentration on a specific document. So most FM clauses that I see don't actually stipulate particular documents. They just say the evidence shall be provided, and it's for the seller or the party relying on the clause to, as you say, collate what material he can collate, be it press cuttings, be it certificates, be it GAFTA notices, and so on. And I suspect the generic approach to phraseology is to avoid this particular issue.
Entirely. Thanks, Fred. I briefly mentioned earlier the phosphor force majeure clause just by way of comparison, and we've put it up there just to see how it differs slightly to the GAFTA sort of prevention of shipments clause. Under phosphor, there's the specific force majeure sort of type clause, and you can see the wording there. It's prevented from loading. So if a seller is prevented from loading the goods on board or prevented from taking delivery, if buyers are prevented from taking delivery, strikes expressly mentioned there amongst other events, then the effect of once the notice has been tendered is to actually extend the delivery period. So it's a type of suspensory performance. They've got additional time. A seller's got additional time to perform. The extension is 21 days lasting. But looking there at the technical aspects of when can a party cancel, it's 60 days beyond that contract delivery period. So if the event happens prior to the kick-in date, you can't automatically claim relief and terminate and cancel. You have to wait to see where you're at the end of the delivery period. You've already got the comfort of an additional 21 days to perform, but then roll on 60 days, and it's 60 days after the end of that delivery period where you then start entering the rounds of cancellation. There is that requirement on the notice requirements, rather than a 7-day requirement from the occurrence of or 21 days prior to the start of the delivery period. You have got the requirement to issue the notice with due dispatch. And this always brings up the argument of, well, what does that mean? Does due dispatch mean within 1 hour, or does it mean you've got some time? We would say best practice is prompt notification. As soon as you are aware that the event in question may, doesn't have to, but it may affect performance of your obligations. Now, under both the GAFTA and the phosphor clauses, we've touched on this evidential requirement. I won't say any more on that for now, because I think we've mentioned it over the last 5 to 10 minutes enough. Suffice to say that I think whether you're able to successfully rely or not on the clause is very, very fact specific. And one can almost argue whether you can avail yourself of a force majeure provision both ways at any one time. But the best advice we would ever give is make it contemporaneous, get that evidence whilst the event is happening, rather than 2 or 3 months later when all of a sudden you're being put to proof. It's much easier to get that evidence at the time of and to show that you're being prevented. Fred, is that you again not putting your hand down, or have you got a comment or question?
Just to focus on prevention, in this particular factual context, as we understand it, having worked on a number of these cases, some terminals did deals with the unions that enabled them to resume cargo operations, whereas others remained completely shut out. Now, where we're talking about prevention, what is the obligation of the seller, for instance, where a rival terminal is available, and it could be possible for that seller to, rather than ship at its own terminal, negotiate with a rival terminal to ship from there instead. And the reason I make the point is because we're talking about prevention and the extent to which a particular clause might require reasonable endeavours to be exercised by the party relying on the clause. You know, does the shipper, the seller, have to do whatever he can in terms of costing, for instance, to ship from an alternative terminal in our scenario where that alternative terminal has done a deal with the union and is now loading?
It's almost akin to the kind of closing all the loopholes that arose out of the soybean cases back in the 70s on the prohibition, the old prohibition clause as it was then. What I would say is that you know, a seller that finds itself actually prevented but can see other operations going on for one reason or another, I don't think it's sufficient to actually say 3-4 months down the line, oh yes, but I couldn't possibly, you know, I don't know what was done there, but we simply could not ship out of this terminal. The advice comes back again to this contemporaneous evidence. Go to that terminal, see, get it in writing whether you're able to ship out of that terminal or not. Investigate. 9 times out of 10, the answer may well be fine, but you're going to have to wait another 3 or 4 months because we've got our own cargoes we're shipping. But it's much better to have that in writing or in some form of memo or a report from agents to say what's possible and what's not possible, than to do nothing at all and try and argue it at a later date.
And in reality, why would the rival help us? You know, it's a tough world there. They're competing with us. So the likelihood is that whatever chance was factually possible wouldn't actually materialize in practice because the rival doesn't want to help us. But it's an important point in terms of looking really carefully at the wording of the clause again, because there's a 19th century case, a judgment by Lord Justice Cockburn, Nugent, who says that where the wording says beyond the reasonable control of the party seeking to rely on the clause, that actually imparts an obligation on that party to exercise best endeavours, to actually show, as you've said, closing the loopholes, to show that there is no way of performance. So if there is an opportunity to load from another terminal and that other terminal is prepared to load at a particular cost, you get into quite an involved and analytical discussion as to whether prevention actually applies there.
Absolutely, yeah.
Darren, I'm old enough actually to remember that 19th century case when it came out. But just lobbing something else in here. I mean, it's occasionally you will have a contract which names a specific terminal, and if that terminal is affected by the strike, you know, arguably, even if all the other terminals were able to operate, the seller would be entitled, wouldn't he, to rely on force majeure because it has prevented performance of the contract, you know, as specified in the clause that says you've got to load out of terminal A.
Sure, but I think you've hit the nail on the head there. Arguably is the word. So yeah, I mean, and again, we come back to the fact you can make an argument either way at any one particular time, but it's going to be a very brave person to simply make a decision, take that position, and then run that right through and litigate it maybe 6-8 months down the line. What might be arguable might not be acceptable, particularly to a commercial tribunal. So rather than simply sit on your hands citing analogous case law to charter parties and saying it says named terminal, can't ship out of named terminal, make those inquiries to see whether it is possible in practice as well as in theory to ship out of another terminal. And you know what, if it's not, you've got the evidence there. And as Fred said and made the point earlier, it's unlikely, even if you go through those steps, it's unlikely a rival terminal will allow you to utilize their services. So it all comes back down to, again, this whole fact sensitive nature at the time. Gather that evidence, collate it, have that in your armory. You don't need to deploy it immediately, but at least you have that for if and when you are pressed at a later point. And equally, of course, you might get several weeks down the road and it's all of a sudden it is possible to resume operations again, business as usual. Another factor with these sort of force majeure events is the unpredictability nature of them as well. It might be announced one day and then the following day rescinded and everything's fine again. So yeah, rather than wait and see, it's react to what is always a fluid and developing situation. Before I finish up on this on this particular case study, I was just going to touch upon the demurrage aspects, because obviously if we look at FOB contracts, a buyer is going to be sort of running up sort of demurrage that he's going to want to possibly claim against his FOB seller. Now, if we look at the GAFTA standard form, it actually does provide an exception to demurrage counting or accruing in cases of strikes. Again, that prevents loading. So provided you can actually, as a seller, cross that sort of threshold requirement of evidence, the causal connection, then you can rely on that clause to actually bat away any claim from a buyer for demurrage during that period. But the reason I've put that point there is because if you look at the phosphor forms, there's no such inbuilt mechanism there covering or dealing with demurrage for a FOB seller. So the advice then would be that a FOB seller on phosphor forms would need to ensure that there is a sort of exceptions or a force majeure regime built into its own sort of bespoke terms of agreeing that would cover sort of demurrage not accruing under a sort of an event of force majeure, because you need to actually specify that. And it's equally applicable, I believe, to a SIF seller too. Jeff, have you got a comment?
Yeah, just very briefly, Darren. So in a phosphor situation where there's no inbuilt mechanism dealing with demurrage in a strike situation, what if the sale contract actually says demurrage as per charter party or some sort of similar wording? What's the position then? Would that be enough to incorporate charter party exceptions and the force majeure provisions in the charter party, so far as they extend to demurrage, into the sale contract?
We would need to look at the exact wording, but if you have demurrage as per charter party, the orthodox view of that is that's applicable to the demurrage rate. That doesn't necessarily automatically import the entire lay time regime set out into that charter party across to the sale contract. And we're then in the realms of debate as to, does your sale contract provide an independent standalone sort of right to demurrage being claimed, or is it an indemnity whereby a FOB buyer, for instance, has to prove an exposure to ship owners before claiming it? So it would really come down to the overall wording in that sale contract and what is provided for the lay time counting as well.
Okay, thank you.
And assuming that's all the comments or questions from the moderators, that brings an end to that first case study, and I will now hand over to John to go through the second.
Thanks very much, Darren. So our second case study is on weather-related issues, and this is based on events from last year as well. So in the second half of 2020, there was a bad harvest across Eastern Europe, and this resulted in lower crop yields and an increase in market prices. As a result, a number of local Chamber of Commerce organisations issued force majeure notices. But does that mean that there was force majeure under the relevant sale contracts? Now, bad weather is not specified as a trigger event in either the GAFTA prevention of shipment clause or the phosphor force majeure clause, which Darren has just dealt with. So turn back to them briefly. Can see that although they may have covered the issues that Darren was discussing, strikes, they don't specify bad weather as a trigger event for prevention of shipment or force majeure. Turning back to the weather-related slide. But both of those clauses do, however, provide for acts of God as trigger events and a sweep-up provision for events comprehended in the terms force majeure. Now, an act of God suggests a natural cause without any human intervention. However, it's only likely to be quite an extreme event that will qualify as an act of God. The parties would have to be effectively overpowered by the natural event. Bad weather is unlikely to be sufficient. We're talking more something like a hurricane or a volcano to qualify as an act of God. Bad weather is also not covered by the sweep-up provision force majeure, and that's established based on case law precedent. Now, one would not therefore normally expect bad weather to be an effective trigger under the force majeure clause. And so in this situation, that kind of claim would be likely to be expected to fail under those GAFTA and phosphor provisions. Fred, did you want to say something at that point?
Sure. It was just to build on the act of God discussion briefly, which is the best definition I found of act of God is actually in relation to the Hague Rules. It's the same 19th century case that Jeff remembers from university days. Lord Justice Coburn says a party essentially is overpowered by storm or other natural agency. So I think what we're looking at in terms of act of God is not simply it's a rainy day or there's a bit of wind. We're looking at an earthquake. We're looking at something catastrophic. And I particularly like the phrase natural agency and the verb overpowering. So it's almost a consuming force that simply cannot be averted in any way whatsoever. I suppose the most interesting classical example is the volcano, Vesuvius, Pompeii. That is an act of God. Okay, an act of several gods because they're pagan, but you can guess where I'm going here, which is a supervening, overpowering force, and it's a natural agency.
Fred, I guess a pandemic would fall neatly into that definition.
Unless it was deliberate.
Well, that's controversial.
Well, that might be a good time to move on then from acts of God.
Good idea.
No, but I think that that case law that Fred has just described, that particular case, really does sum up the significance of that term very neatly. So that's dealing with the trigger for force majeure, whether weather-related issues would satisfy such a trigger. There'll then be an issue of, in this case, there was an issue of timing under the phosphor force majeure clause, as I think Darren already described. The sellers claiming force majeure are required to notify the buyer of the force majeure circumstances with due dispatch. So I think Darren had that highlighted in his slide. You can see at the bottom. Well, it's in both of those clauses, but specifically we're talking about the force majeure clause in the first paragraph there. The bad weather, as the alleged trigger event in this case, occurred earlier in the year, even though it may have caused problems later in the year. It therefore seems that sellers would have been obliged to give notice much earlier in order to satisfy the requirement of due dispatch under the phosphor force majeure clause, at least. The most important point, however, and again, this is something Darren has already it's equally applicable to the case study he discussed, is the issue of prevention, and the fact that the bad harvest did not prevent export. It only reduced the quantity of goods available and increased the price. The fact that the contract may have been more difficult to perform or more unprofitable would not amount to prevention. In order to succeed with a force majeure claim, sellers would have to show that no goods were being exported from the place of shipment. That would be prevention. Unless anyone has any questions at this point, Fred, do you want to step in at that point?
It was really just to emphasize that there could be compounding or layers of different factors. So in this particular case study, we have a drought that leads to a bad harvest. And we've already discussed that fitting that within act of God, for instance, might be difficult if it's not sufficiently extreme. It's the kind of an exercise in relativity. But then we then have the scenario where the government reacts by imposing either a qualified quota system or a complete absolute prohibition on export. And then we get into a new debate, don't we? Which is that we then fall slap bang right in the middle of the prohibition element of the GAFTA Prevention of Shipment clause, or the phosphor discrete prohibition clause. So, you know, it might not just be one factor. It could be one factor that then leads on to another, a chain reaction, essentially. And in the end, you end up slap bang right in the middle of one of these clauses.
Yes, indeed, something like that would change the analysis as to what was the proximate cause of the alleged inability, and if it was a prohibition on shipment, then you'd be looking at a different trigger, really, and you'd expect it to satisfy the GAFTA prevention of shipment clause and the phosphor prohibition clauses, Darren, as was set out in Darren's previous slides. But again, you still have to satisfy the issue of prevention, and if the sellers could still perform in an alternative manner by shipping from another place, then that would they wouldn't be considered to be prevented. So that brings you back to looking at what the contract provides for in terms of the goods and where they're to originate from. So if you've got options, if it's Ukraine or Russia, then you're only prohibited from shipping from one, then you have to take the alternative means.
And the second point I'm going to make is in relation to the charterer. Again, the FOB buyer, CIF seller, who's chartered the ship and very much is caught in the eye of the storm, the eye of the hurricane. I've never seen a charter party which contains a specific prohibition clause. What the charter will normally do is contain an exceptions clause, which might, for instance, refer to restraint of princes, or a legislative act of some sort which prevents execution or performance. And that is a real risk area for this party caught in the middle, because it's clear under the phosphor or GAFTA contract that the prohibition will protect that party, because there are express clauses, terms dealing with prohibition. The charter party is going to be rather different. And again, a charterer seeking to rely on force majeure to protect itself from an owner that wants to claim hire or demurrage, where we're in a prohibition scenario, it's going to face a little bit of difficulty. And again, it's trying to stay back to back where possible. But there is a disconnect in this situation between the sell contract as a type of contract and a charter party.
Yeah, absolutely. Thanks very much, Fred. Unless anyone has anything else to add on that, I'll hand over back to Darren for the final case study.
Thanks very much, John. So skipping from South America over to Eastern Europe, and now we're into China for the final case study of this webinar. The focus here is on import bans, and so to give it some flavour, we go back to 2020, and it was sort of a big trade war going off between China and Australia. And China's first step was to actually suspend imports well, the second step. The first step was back in May of 2020, when China just placed 80% tariffs on the import of Australian barley. So we saw that as an indirect ban of imports, but not an outright one. They then went a step further several months later by sort of singling out CBH Group. No secret that at the time, CBH Group is Australia's largest barley exporter. And they banned imports, well, suspended rather than banned, suspended imports of barley for the time being back in September from CBH Group. So that was the latest development. That's what was going on during the course of 2020. And in the background to all of this, you hear about examples, you hear about rumors are abound, where sort of Chinese ports accepting vessels laden with Australian cargoes. Doesn't matter what was on board. There was a sort of so-called go slow policy for berthing those vessels, rather than a complete ban or a complete obstruction. And additionally, there was evidence at the time that a number of vessels were being discharged by negotiation with individual port authorities. And even at one stage, we saw an example where the government of the vessel's crew extended to making representations to the Chinese government in order to allow a vessel to sort of berth and unload and discharge. So in the background to this is the fact that the actual ban itself wasn't express. It's all very indirect, and the closest we got to it was this targeting of a particular company, where rather than saying all imports are banned, it was we're suspending imports for the time being. So in that context, the question then becomes, does this qualify as a force majeure event? I'm not going to skip back to those GAFTA prevention of shipments and the phosphor force majeure slides, because the simple answer there is that those clauses do not apply to import bans, because an import ban does not affect or prevent the export of the commodity in question. So those clauses we looked at earlier and the examples we were looking at earlier in the previous two case studies are all events occurring at the load port. So those clauses will not help in the situation where a buyer is prevented from importing at either the country, the intended country of destination. So what next? Well, John touched on this going through the general principles. If there's no other bespoke clause in the contract, one then looks at what sits side by side to force majeure as a subject, which is the English common law principle of frustration. And in these circumstances, frustration may be able to step in to protect a buyer involved in sort of suffering from an import ban. However, in order to make frustration out, you have to be able to show that the ban itself has actually prevented performance of the contract in question. And not only in the example of the China-Australia trade war last year, not only do you have the hurdle of the fact that it was all very suspensory and it was all very indirect, even if you're a seller on CIF China terms, that's no guarantee by the seller that those goods going to China will actually be imported into China. And the case listed there, Bangladesh Export Import Company in Sukden, is authority for that. So there's no guarantee that these goods are going to be imported into China. So that's not going to help a CIF buyer too much. And the next comment to make in this regard is something we've started to see more and more over the years, is that the contract terms in question between seller and buyer, do they actually provide for import into a particular country? And there's the role here of the documents required for payments. And the answer there is, if those documents do provide for payments, certain obligations, for instance, a requirement for a certificate of origin or a phytosanitary certificate to be legalized by the embassy of the country of destination, you're starting to enter into the realms thereof looking at those clauses and saying, well, that's a clear indication that both parties know that the goods are going to be imported into, for instance, China. So therefore, there is an argument open there that this is a contract for import rather than just a standard CIF China contract. Jeff, do you have a question?
It's more of a comment, really, Darren. I just wonder, you would have a bit of an uphill struggle, I suspect, in saying that just because the seller is obliged to procure a document and have it legalized in a particular destination, that turns the contract into one where the buyer is obliged to import into the country of destination. We all, we all know the truism that a CIF or CFR contract is a sale of documents, not a sale of goods. I find it difficult to see how a CIF seller who's actually procured the document from destination and presents it in the face of an import ban, before the import ban comes along, he's already got his ducks in a row and presents his documents. I would have thought that seller would expect to be paid, rather than the buyer saying, well, I'm preventing from performing the contract.
And Jeff, I was just going to add there that if it's a letter of credit based transaction, there's nothing to stop the seller simply going to the buyer's bank and presenting the docs and getting payment. And then the buyer's going to be left back at square one anyway.
Well, absolutely. I mean, again, we go back to this whole, when this import ban is announced, it tends to be announced by a government of the day without any thought process as to the knock-on effects of this. So you're quite correct. A buyer that has already seen goods being shipped and the seller that's already procured those legalization documents and presented them for payment under a letter of credits, the buyer is not going to really want to be interested in immediately claiming frustration, because he can see there's no real get out clause here unless there are express terms provided in the contract. And here we're talking about frustration, so of course there are no express terms. If the only argument for the fact that this is a contract for import into China and it's frustrated now and I can't pay or sort of take the goods, is this requirement in the sort of the payment clause section for legalization, etc. As a buyer, I think you would be more interested in negotiating locally to see whether these goods can be imported, because query, when does that import ban bite? Is it immediately, so ships that are waiting at anchorage to berth are unable to and they have to find homes elsewhere, or does it just simply apply to goods that are shipped to intended for that destination, so goods to be shipped rather than goods that have shipped? And that's the entire factual matrix that you do tend to find as soon as something is announced. There's several days of representations from local trade associations, local chamber of commerces, where these kind of wrinkles are ironed out, and you are in that negotiation stage. So what I was going to say next is, if you're just looking at that term in particular, you are going to be a bit stuck, and what you are looking for is the wider contractual provisions and whether there is destination China in there or import into China guaranteed, which is fairly rare in our experience. Fred, you've got a comment?
Yeah, it's just a couple of points, Darren. The first goes back to your citing of Bangladeshi exports versus Suckton, and the basic principle being that a CIF seller isn't obliged to guarantee imports, and that this may be modified by documentary requirements like a GMO certificate that is certified at destination. And that is that I've been involved in one arbitration where the existence of these documentary requirements in relation to GMO gave rise to an argument by the buyer against my client as seller that there was a potential breach of Section 14 of the Sale of Goods Act in terms of fitness for purpose, that it wasn't just sufficient for the seller to procure the documents and ship the goods in compliance with the specifications, but that there was a further duty to effectively load goods that were suitable for import into China. And that was quite a novel argument. And there was a straw poll run by the barrister that I instructed within chambers as to the merits of that point. And interestingly, the sort of the conservators said, no, that's never going to fly, never going to fly. But the radicals said, actually, there's an argument there that can be run, that here the CIF seller is actually guaranteed importability and is potentially in breach of Section 14 of the Sale of Goods Act, but the results of the straw poll were 50-50. So 50% of these very clever barristers thought it was a runnable argument, and the other half didn't. And I suppose the takeaway there is that, again, these are very fact-sensitive discussions, and they're extremely finely balanced. The second point I wanted to make related to charter parties again. We mustn't forget that the CIF seller has chartered the ship, and he's got to deal with his obligations under that charter. And that gives rise to some very difficult scenarios. For instance, if there is a very lengthy delay, but he's got the vessel on time charter for a period, frustration is going to be impossible. And he may just end up having to renominate another discharge port somewhere else, if he's permitted to under the terms of the charter. If he's a voyage charterer, it's just going to be one destination, and he could be stuck there for a very long time. And then you get into a knotty debate as to whether the delay is sufficient to frustrate the voyage charter, where that charter provides for demurrage for delay in discharging, congestion, etc. So we mustn't forget the position of the charterer as well, and the slightly different types of debate that can follow as a consequence.
No, absolutely. I think a follow-on point to that, Fred, with your voyage charter provision there, is that if you've got one that's you see some requirements at where you get discharged, China ports, for instance, there could be add-on wording also near there to as she may safely get as well. So in that sense, there's going to be an obligation on the vessel owner and an ability to actually be able to go to any alternative port where that vessel can discharge. So in that sense, the charterer presumably would not want to just allow the owners to have free-for-all as to where that vessel goes, and would want to negotiate alongside the buyer as to where those goods will end up.
And of course, where we go back to the pandemic, a lot of these charter parties contain contagious diseases clauses that actually give owners swinging, wide-ranging powers to do anything they basically want. And half our life in the past year was actually helping charterers trying to tweak these clauses to give them a little bit more protection.
Entirely. Unless there are any other comments or questions, sometimes it's difficult to tell. That brings me, I believe, to the end of that particular case study. And I will hand back over to our one of our moderators, Jeff.
Thank you, Darren. Thanks for that. We've pretty much reached the end of this webinar. We thought it would be an idea just to try and draw together all the various strings that have been discussed into a series of useful tips. Starting off with contract terms, always be aware of the force majeure provisions in your contract and be aware of them as execution of the contract proceeds. Now that sounds a bit simplistic, I know, but remember, as we discussed earlier, there are three potential sources of force majeure provisions that may apply to you as a contracting party, as the contract you've negotiated, the phosphor, GAFTA, sugar association terms you may have incorporated. You may also have the parties' standard terms and conditions that apply. If those terms and conditions have been drafted by lawyers, you can bet the house on the fact that they will include force majeure provisions, because lawyers cannot resist putting force majeure provisions into standard terms and conditions of trading. So you need to employ a wide-angled lens when considering the force majeure provisions that that may apply. That there are likely to be multiple sources. Always be aware of what requirements there may be in the force majeure provisions for giving notice of the force majeure event to your counterparty. Just trying to navigate forward. There we go. As we've seen, if failure to give that notice on time or to include required details or required supporting evidence may well result in your actually forfeiting the right to rely on force majeure. So in particular, then, as part of ensuring that the force majeure notice you give conforms to the requirements of the contract, there are some steps you need to ensure that you take. Make sure that the notice identifies the force majeure event in question specifically. Don't just say force majeure has occurred. I can't perform this contract. That is not likely to be good enough. You must specify what the force majeure event is that you intend to rely on. You can even employ an old lawyer's trick here. In other words, be specific enough to cover the force majeure event in question, but be vague enough that the notice could cover as many other likely force majeure events as possible. So hedge your bets, but make sure that you specify the event in question at the beginning. Remember to include with the notice all the evidence that the contract requires you to provide when giving that notice. As we've seen, contracts can be very specific about the evidence required. They can, for example, specify you should provide a specific certificate from a specific chamber of commerce confirming some very specific events. So you need to watch out for that. And as Darren said in his presentation, send out the scouts pretty quickly to make sure you start gathering this evidence pretty quickly. And if you can't gather it, gather evidence that you can't gather it, if you see what I mean, so that you can provide that to the other side and to the arbitrators to excuse your non-performance with that particular requirement. Always, therefore, say in your notice that you reserve the right to supplement the evidence that you have provided in due course, and that'll give you the wriggle room to plug gaps in the evidence later on. And crucially, as Darren also mentioned, make sure in your notice that you do not refer to the force majeure event as cancelling or terminating the contract. As we've seen, most force majeure clauses are suspensory in nature. In other words, they suspend performance of the contract for a specified period, and they then only provide that the contract will come to an end if the force majeure event is continuing to disrupt or prevent performance after that period of suspension has elapsed. And that's very important, because if you get it wrong and you suggest in your notice that the force majeure event has actually cancelled the contract, that could well amount to a renunciation of the contract by you. In other words, it could well be regarded as a statement by you that you definitely cannot or will not be performing your contract. And your counterparty could jump on that and take the opportunity to terminate the contract against you. So you need to be very careful with the wording of your notice. And also, when firefighting a force majeure situation, make sure that you stay back to back as much as possible in not only in the notices you give, but in managing the situation overall. It's crucial that you don't get out of step if you have counterparties on either side of you, each of which may have varying force majeure provisions prevailing. Gone too far, do apologise. Evidence. We've already talked about evidence a lot in this webinar. This is one of the most crucial aspects of relying on force majeure. The evidence you may be required to provide with your notice that a force majeure event has occurred that's simply the beginning. It's vital that you also collect the evidence that the force majeure event itself has hindered or prevented your performance of the contract. So just because the harvest has been badly affected by bad weather, that won't automatically excuse your non-performance. You have to build a causal connection between the force majeure event itself and your inability to perform. And that means collecting the evidence. You also need to create a paper trail of evidence relating to your efforts to perform the contract despite the occurrence of the force majeure event. We've already talked about having to show that all your alternative options for performing the contract were impossible. So, for example, just because you intend to get your goods to the load port by rail doesn't mean that a railway strike prevents performance if you could just as easily get the goods to the load port by truck or by barge. Another example in relation to strikes. We've already seen if there's a strike at your intended load terminal, you'll need evidence of the steps you've taken to see whether loading might be possible, either at that intended terminal by a bit of what I might call judicious and persuasive local negotiation, or perhaps at another terminal. And the arbitrators, you can bet the house on the fact that they will be very alive to these points, and you'll need to ensure that the evidence you have satisfies them. So finally, what sort of evidence might you look for here? Well, there are three examples up on the slide. So we've got evidence from local agents, local press reports, notices issued by GAFTA or possibly other trade associations. And I would add three to that list. The first is you might want to get a witness statement from a local supplier, for example, or maybe evidence from a local trade association or a local chamber of commerce. And finally, I'd add to that list, think about using local lawyers at the place in question. You can get some invaluable help from a trained legal mind that knows precisely what you need and why you need it. And I'll give you an example of that. I was involved a while ago in a sugar case, and it involved smugglers putting drugs in containers of sugar while they were at Santos port in Brazil awaiting shipment. And I asked my go-to Brazilian lawyers, who I think may be attending today, so that's why I've mentioned them. I asked them about this, and they gave me the most fantastic 25-page dossier recording precisely how the smugglers operated and how they did what they did. And that was absolutely invaluable for the case. So don't discount the value that local lawyers can add. And that, in a nutshell, are the hot tips that I thought would summarize all the discussions that we've had today. And that's it, ladies and gentlemen. We've been going for 1 hour and 23 minutes, and Darren has his hand up, so I'm going to give over to him for a second.
Thanks, Jeff. I just wanted to mention something in case you weren't going to say this. If you were, apologies. But for those people that were late in joining, that missed the first couple of introductory slides, a copy of this presentation, as well as the recording, will be distributed sort of at some point later this week, early next week. And picking up on that, I see from one of the comments, Mr. Rooks has picked up on the typo, despite or several of us going through this these slides about 10 times in the past week. And of course, when I set out that GAFTA prevention of shipment delivery clause earlier, I took that off of the GAFTA 49 form. And what I forgot to do, and this will be my mistake I own up to here, unusually, Fred would say, I should have actually just put 49 in brackets, being the FOB equivalent to GAFTA 48. So when the slides are distributed, it will be with hopefully all typos taken care of. Jeff, back over to you, sorry.
I was just going to say, Darren, it just goes to show how closely GAFTA arbitrators scrutinise documents, not just GAFTA prevention of shipment clauses, but also presentation slides. So thank you very much, Roger.
Darren, you did actually take the wind out of my sails there. I did have that noted as something to say. So all I will add is that what we will also be circulating along with the slides and the recording, the question and answer sheet, just to pick up some of the points that we've discussed. So all that's left for me to do really is to say thank you to those who have attended. Thank you for coming to listen to us and giving us your time and attention. I hope very much that you've learned or heard something that is of interest to you. And the four speakers and I very much look forward to seeing you next time. So thank you very much.